Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that the defendant is present with the same attorneys and the same prosecutors are present. Before we get to Ms. Nelson, let me make a record about a couple of other things with respect to the instructions. In terms of all the instructions that mention the term universal malice, my understanding, Ms. Nelson, is that you don't want me to give a definition of universal malice. And as you know, universal malice is not defined by statute. But the case law contains a few different definitions or comments. The one that comes up most often is that universal malice is defined as that depravity of the human heart which determines to take life upon slight or insufficient provocation, without knowing or caring who may be the victim. That's from People versus Jefferson, 748 Pacific 2nd, 1223, Colorado Supreme Court, 1988. And originally it was from Longinati versus People, Longinotti, 46, Colorado 173, 102 Pacific 165. That's a case from the Colorado Supreme Court from 1909. And People versus Ellis, it's a Colorado Court of Appeals case that also has that definition. That's cited at 30 Pacific 3rd 774, Colorado Court of Appeals 2001. But I think that the definition originated in Longinati, and in other cases I've quoted it since. In People versus Rodriguez, 888 Pacific 2nd 278, Colorado Court of Appeals from 1994, the court stated that the element of universal malice required for extreme indifference murder has been defined as aggravated or extremely reckless conduct. And the court cited to People versus Jefferson for that proposition. And then finally, in Longinati, the court also said that universal malice is evinced by acts which are calculated to put the lives of many persons in jeopardy without being aimed at anyone in particular. My understanding of the conferences that we've had on jury instructions is that the defense is asking the court not to give any of those instructions. Is that correct?
Yes, Your Honor.
Okay. And the people are not seeking that any definition be given on universal malice?
I don't think it's necessary, Your Honor.
Okay. I came up with a list of admonishments for the alternates. I'm going to deviate from the instructions for just a moment because I don't want to forget to do this. And I came up with 10 admonishments. And what I'm intending to do is have them blown up and have them in the room where the alternates are going to be. So I'm going to have my staff make you a couple of copies of these, of the admonishments so that you can see them. But for the record, they read as follows. Number one, please do not discuss any aspect of the case with each other through any means. You are free to talk to each other. There's a typo there, and I'll fix that. You are free to talk to each other, but not about the case. You are not allowed to deliberate in any way or discuss any aspect of the case. Number two, in addition to not being able to discuss any aspect of the case with each other, you may not communicate about the case with anyone else through any means. All you can tell people is that you're a juror in a trial in Arapahoe County that is expected to end at the latest in August. Number three, you may not have any contact or communications with any jurors who have been dismissed or with any jurors who are deliberating. Number four, please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. Number five, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you are on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. In the event that, despite your best efforts, you hear something about the case, please let my staff know that you want to talk to me. Number 6, please do not talk to any members of the media about anything until these proceedings are completed. Number 7, you must not read, view, or listen to any news or media reports that may refer to this case. Because there's media coverage of this trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. Number 8, you cannot visit any locations mentioned in the case, nor are you allowed to conduct your own investigation outside the courtroom. This includes consulting outside references in relation to this case or a case like it. Number 9, all decisions in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I provide. And number 10, you cannot form any opinions about the case or deliberate internally, and then in parentheses it says privately, about the case. You must resist any temptation to deliberate. I'll give you a copy with that correction, but generally, any objection from the people to having that in the room where the alternates are going to be held?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
All right, great.
Not as far as we could follow along anyway.
Okay, thank you. Before I forget, I wanted to make a record about the fact that we had an initial jury instructions conference on June 24, and then we had another one on July 2nd, and then we're having this one today, July 13. And I want to incorporate by reference the record I made on July 2nd as well. We did not have a conference on July 2nd, but I gave the parties a draft of my instructions. That's the draft of the instructions that we worked on last Friday on July 10. And I made some comments on July 2nd. It was toward the end of the day on July 2nd, related to People versus Bielecki, B-I-E-L-E-C-K-I, 964 Pacific 2nd, 598, Colorado Court of Appeals case from 1998, People versus Collins, 752 Pacific 2nd, 93, Colorado Supreme Court case from 1988, and Colorado Revised Statute Section 16-8-105.5, subsection 3. And based on, or I should say that the comments I made were to reflect that I had changed the initial draft of the instructions that I had distributed to the parties. And the reason for at least some of those changes had to do with the authority that I just cited. And I explained that on July 2nd, neither side responded, although I could see that both sides were seemed to be a little surprised by my comments. I allowed the parties to review that draft of the instructions, and then we returned last Friday to discuss the instructions further. That was on July 10. And then we worked on July 10 on the instructions, or the draft of the instructions that I distributed on July 2nd. And then based on the conference that we had on July 10, last Friday, I created a new draft, and that's the draft that I distributed today. So I wanted to incorporate by reference the record I made on July 2nd. I also wanted to make a record with respect to a couple of comments that I made. I think it was on July 10, and it may have been on June 24 as well, but I'm pretty sure last Friday I said that just because something is in the case law, or just because there is law on something, doesn't mean that I should instruct the jury on it. And I said there's case law on this in Colorado, and I found that case law over the weekend, and so I wanted to incorporate it into the record now. It's People versus Lane, L-A-N-E, 343 Pacific 3rd, 1019. That's a Colorado Court of Appeals case from 2014. And here's what Judge Gabriel said in that opinion. And Judge Gabriel, as you know, has just been appointed by the governor to be the new justice on the Supreme Court. As our Supreme Court has made clear, a trial court's use of an excerpt from a judicial opinion in a jury instruction is generally an unwise practice because opinions and instructions serve very different purposes. The court then cited to Evans versus People, 706, Pacific 2nd, 795, Colorado Supreme Court case from 1985. The court in Lane went on to say, in Cohen versus People, that's C-O-H-E-N, 106, Colorado 245, 103, Pacific 2nd, 479, Colorado Supreme Court case from 1940, the court explained that statements taken from opinions do not necessarily translate with clarity into jury instructions because opinions and instructions have very different purposes. Language used in an opinion pertinent to the issues and the determined facts in that case may be a proper expression of the law as related to those facts and issues and pertinent to a decision of the case, and yet may not be sufficiently general, clear, or accurate to serve as a satisfactory or full instruction to a jury. So I wanted to supplement the record with respect to that. One more supplementation of the record. And for this one, I'm going to need the one attorney to approach. I just want to make sure we're all on the same page in terms of who we think is a deliberating juror and who we think is an alternate juror. So would somebody please approach with your list of alternates or unless you haven't memorized? Or can I give it to you now and then check and then tell me tomorrow if I misstated? Is that all right?
Yeah, I have a pretty good memory, but...
All right, do you want to approach, why don't you approach him so I can give you my what I show, and then you folks can tell me later if you disagree. Just one last thing, just as a follow-up, because I don't want to forget, Mr. Orman, you had indicated that you were going to follow up on the penalty phase instructions that you submitted to see whether they had been the type that have been reviewed by the Supreme Court and had in the past. And I know we just had the conversation on Friday, and you may not have had an opportunity to do that. I'm not asking you about it now. I'm just saying if at some point you find out additional information, then I would like to know that, okay?
Thank you.
All right, thank you. All right, let's get to the instructions then. Ms. Nelson, have you had an opportunity now to review the latest draft of the instructions and the verdict forms? And for the record, we will post them so that, not post them, but we will put them in the court file so that the record is clear as to what the draft of the instructions that we've been talking about today looks like. So, Ms. Nelson, where would you like to start?
I think it might make sense to start with the informational instruction about the consequences of a not guilty by reason of insanity
Okay, let me get there.
verdict.
Okay, go ahead.
We continue to maintain our position that the instruction on this issue that we submitted should be given, but without waiving that position. We do prefer this new version over the previous draft version that the court had circulated. I would ask the court to consider changing the court's duty to commit him to this court's duty to commit him, since it will clearly be this court and not just a court. And that goes along with what the court was saying earlier about changing and personalizing a little bit to the defendant. I think it's appropriate to say that it will be this court that commits him to the custody of the Department of Human Services.
I agree with you. Is there any objection?
Much better the way it's written right now, Your Honor. I think it's very clear.
Well, I mean, it is sort of semantics. I mean, it is the court is this court, so.
It's not necessarily you, Your Honor. I mean, you could go on to other duties in the future, other courts. And I think that when you say this court, that is saying it's going to be you.
But this is talking about the duty to commit him, not with respect to whether he's eligible for release. So this is if the defendant is found not guilty by reason of insanity, it will be this court's duty to commit him to the custody of the Colorado Department of Human Services until such time as the court determines that he's eligible for release. I don't think we need to change both, but the way I understood Ms. Nelson, she's asking to change the first one where it says it will be the court's duty. Right, Ms. Nelson?
Yes. Well, I should say that at the previous charging conference when we discussed this instruction, we had asked the court to change both, but I understood the court to have already rejected that request, and so my new request would just be to change the first reference to the court to this court.
Mr. Orman.
Well, certainly, Your Honor would be the one doing that, but I think that by changing it, you imply that it would definitely be Your Honor doing the latter, and obviously that may be the case. It may not be the case. So I just think it makes it much more confusing.
And I disagree, Your Honor. I just think that it makes it clear that it's this. It doesn't say that you personally would be doing it. It says this court, which is the Arapahoe County District Court. And certainly it will be you committing him to the custody of the Department of Human Services if there is a not guilty by reason of insanity verdict. And then I think it's appropriate, given the court's ruling at the earlier charging conference, to just keep the second reference to the court as the court.
I'll change the first "the court" to "this court." I don't think there's anything I don't think that makes it more confusing in any way, and I think it's accurate. So it'll say, if the defendant is found not guilty by reason of insanity, it will be this court's duty to commit him to the custody of the Colorado Department of Human Services until such time as the court determines that he's eligible for release. Frankly, this court doesn't necessarily refer to me anyway. It's this court. I am the judge assigned to this court, but I think saying this court will have a duty to commit him is appropriate, and I think that's accurate. So, okay, what else?
And then we would just we would ask the court to consider adding the paragraphs that we had proposed in our initial instruction about the burden of proof being on the defendant to establish that test, as well as adding the language that we proposed in our original instruction, conveying that the court can impose such terms and conditions. If the court finds the defendant eligible for release, the court can impose such terms and conditions as the court determines are in the best interest of the defendant and the community, which just makes it clear that it's not just, the defendant just being sent on his way without any additional court supervision.
Your Honor, I think we had a long discussion about this the last time, and there were many aspects of the defendant's proposed language that we believe were actually factually inaccurate. This language is accurate, it is easy to understand, and as Your Honor indicated earlier, these should be brief and easy to understand, and not the way a law school lecture would undertake to present this topic. And the court's instruction is a much better instruction.
I agree, and there are all kinds of details in the statute, and I mean, you get into a slippery slope. How far do you go? How many details do you give the jury? And if you only give some details, do you run the risk of giving an incomplete instruction or a confusing instruction or an instruction that misleads the jury? If you get into the burden of proof, then at that point, why don't we get into a hearing, and when the defendant is entitled to a hearing, and how the court in some situations has to have a hearing, and what the procedures at the hearing would be, and what type of evidence the court would have to consider at the hearing. I mean, if you get going into one of these details, then I think to be fair and complete, you have to include all the details, and then if you include those other details, you have to include additional details, and pretty soon you're giving the jury a mini law school course on eligibility for release. And by the way, this is not an uncomplicated topic. If you go through all those details, there are procedural requirements, there are substantive issues, there are all kinds of concerns and considerations involved. And I don't think what Thompson had in mind was to give the jury all the information available on the subject matter. What Thompson had in mind was to make sure that there was not a miscarriage of justice as a result of the jury assuming that a not guilty by reason of insanity verdict would be the same thing as a defendant walking out of the courtroom just as if he was found not guilty. So the request is denied. And I incorporate by reference any other comments that I've made in previous jury instructions conferences on this issue. Anything else, Ms. Nelson, with respect to that one?
No, Your Honor. Is the court referring, is it Thomas, People versus Thomas, or Thompson?
I think it's Thomson. Thompson.
Thompson. Okay, I'm sorry.
Yeah, I think that's the name of the case.
Yeah,
Thompson.
no, that's it for that one.
Okay.
And then next, if we could discuss the theory of defense instruction.
Okay, let me get there. Got it.
We would ask the court to consider, we have a few proposed revisions and changes, but without waiving our request to submit our initial original instruction.
I just want to make sure we have a record of this. Is the court going to make this packet of instructions some type of court exhibit so that we make sure that we have a copy of the one that the court drafted in the record in case it needs to be referred to by another court later on?
Yes, as I said, I will file this draft. But just to be safe, just to be on the safe side, and I intended to do this, and I should do it now, let me read it into the record, just to be clear. Here's how I redrafted the defense's tender theory of defense instruction. It reads as follows. It is the defendant's theory of defense that he was insane at the time of the commission of the acts. The defendant asserts that he suffers from a chronic and serious mental illness with psychotic features, which falls within the schizophrenia spectrum of disorders. The defendant further contends that in the spring of 2012, his mental illness worsened. The defendant claims that around that time he experienced his first psychotic break and began to suffer from a psychotic delusion that he could increase his self-worth by gaining human capital and killing people. And human capital in that sentence, by the way, is in quotation marks, because that's how it appeared in the defense's standard instruction. The defendant, and it's like that every time that term comes up, and again, that's consistent with the standard instruction. The defendant acknowledges that he engaged in planning and preparation, but avers that he did so as a result of a delusional belief and psychotic thought process with the purpose of pursuing a psychotic delusion that he could increase his self-worth and human capital by killing other people. The defendant maintains that his delusional belief system was born of his mental illness, obscure his ability to make moral distinctions, render him incapable of understanding that his actions were wrong from a societal perspective of morality, and interfere with his ability to act with reflection and judgment concerning the charged offenses. Ms. Nelson.
And Your Honor, just to make sure that I made a clear record about this on Friday, our request would be that instead of the defendant, the court refer to our client as Mr. Holmes.
You did, and I denied their request to be consistent throughout because I used the defendant throughout the instructions, and so I think it makes sense to be consistent. What else?
We would request that instead of, in the second sentence, instead of having the defendant asserts, the defendant states. And that we would also request the same change for the next two sentences. So instead of the defendant further contends, the defendant further states. And instead of the defendant claims, the defendant states.
What's the people's position with respect to those three requested changes?
Object, Your Honor. That almost implies that the defendant himself is saying this. The defendant states. That's, I think, the implication of that particular verb. I think that the way the court has drafted it is much more correct and accurate.
I agree with Mr. Orman. I mean, these are assertions by the defendant. It's the theory of defense. I don't know whether the jury may infer something incorrect or wrong from states. He did not take the witness stand and did not testify, and saying state almost seems like a substitute to that. So I'm happy to change contends and claims to asserts, if you like that better, or I'm happy to use a different term. And frankly, I will change asserts if you don't like that either. But it has to be, I think, accurate in terms of this is what he's arguing, this is what he's asserting. So, Ms. Nelson?
I think our preference then in that case would be to change everything to asserts.
Asserts? Okay, I will do that. So then it will say in the third sentence, it will read, the defendant further asserts, and then in the next one, it will read the defendant asserts instead of claims.
Yes.
Okay, great. All right.
Can I make a similar change for avers in the next paragraph?
Well, I don't know. We haven't gotten there yet. Do you have any, with respect to the next paragraph, are you requesting that I do the same thing with respect to avers?
I do, but I also have a additional requested change to that sentence, so maybe let's stick to the first paragraph, and when we get there, I can explain what it is.
Sorry. Yes, I think that makes sense.
So we would also ask the court to consider adding a sentence after the second sentence. So it would read as follows. I'll read the second sentence first, and then I'll read the proposed additional sentence and explain why we think it's necessary for the court to add it. The defendant asserts that he suffers from a chronic and serious mental illness with psychotic features, which falls within the schizophrenia spectrum of disorders. Then we would request that the court add the following sentence. The defendant asserts that he exhibited subtle signs and symptoms of an emerging mental illness for years leading up to the tragic events of July 20th, 2012. And the reason that we think it's important to include a sentence regarding our theory of how this mental illness developed for Mr. Holmes is because there's a dispute between the parties. The prosecution seems to be arguing that Mr. Holmes was born with these fixed personality traits that later caused him to commit these acts, or it played a role in what happened. And our position is that he suffers from a mental illness, and that these subtle signs of mental illness that have been discussed by the experts emerged over the course of a number of years. And so that's why it's important to us to have a sentence in the theory of the case instruction reflecting that difference in position.
All right, Mr. Orman?
Not supposed to be a substitute for closing argument, and the defendant can certainly argue that, but I believe that the sentence proposed by counsel is argumentative, and words like subtle and so forth I think are grossly improper for a theory of the defense instruction, and I don't think that's necessary. Again, they are going to get 2 hours to do a closing argument. The purpose of this instruction is not to take that closing argument back into the jury room with the jurors in written form.
And frankly, as I drafted this, I felt I was being fairly generous and allowing more, erring on the side of allowing more as opposed to less. But and I thought about the sentence that Ms. Nelson just mentioned. I think that sentence is more argument than theory of defense, and I think it's more appropriate for closing argument than adding it to the instruction. Furthermore, the sentence that follows, I think, takes care of it, because it says the defendant further asserts that in the spring of 2012, his mental illness worsened. The only reasonable inference to be drawn from that is that the defendant already had a mental illness prior to the spring of 2012, and that mental illness worsened, that it became worse in the spring of 2012. So I think it makes the point, and it does it in an appropriate fashion. It's not argumentative, and you get the idea out there. So I don't think, I think once you get into the details, such as were these subtle signs and symptoms of something, or was it something else? Was it a mental illness? Was it something else? When you get into terms like subtle, emerging, it just, to me, seems argument. That seems more like argument than the kind of thing that belongs in a theory of defense instruction. So that request is denied. What's next?
Then at the beginning of the second paragraph, we would ask the court to consider adding a sentence, the defendant asserts that planning and preparation is not inconsistent with mental illness, psychosis, or sanity. That's somewhat of a restatement of one of the original sentences that we had submitted with our theory of the case instruction, but adding the defendant asserts language to the beginning of that sentence to put the rest of the sentence into context. The rest of the paragraph into context.
Mr. Orman.
I think the proper verb for that sentence would not be asserts, it would be argues, because that sentence is completely argumentative, and we would object to it.
And that's why I didn't put it in there. I think it is improper. I think it is argument, and furthermore, the point is made in the second paragraph anyway. That's what the second paragraph is about, and especially the first sentence in the second paragraph says, the defendant acknowledges that he engaged in planning and preparation, but avers that he did so as a result of a delusional belief and psychotic thought process with the purpose of pursuing a psychotic delusion that he could increase his self-worth and human capital by killing other people. The statement that Ms. Nelson is asking me to add is a general statement about whether planning and preparation means something or doesn't mean something, or whether it's consistent with something or not, or inconsistent with mental illness specifically. And I think that's argument. That's a general statement. That's not even a statement that is specific to this case. That's a general assertion, a general argument that I know that parties disagree on. And I think that's, again, more appropriate for closing argument than a theory of defense instruction. And furthermore, as I said, it would be cumulative and repetitive, just as the last request to add would have been cumulative and repetitive. So that request is denied. What's next?
So then with the first paragraph of the first sentence of the second paragraph, we would request that the court rephrase it in a few respects. We would ask that the court change avers to asserts.
Okay, that request is granted.
And then next, we would ask that instead of stating as a result of a delusional belief, the court change it to read as a result of his delusional beliefs, plural, which is consistent with our theory of defense of the case. It's not just a singular delusional belief. There were multiple delusional beliefs that were referenced by experts and described as it's a belief system. And that was the way that we phrased it in our original proposed instruction.
Okay, you're right. That is how it's phrased in the original. All right, Mr. Orman, any objection? I have changed avers to asserts because that's consistent with my previous rulings, changing contends to asserts and claims to asserts in the first paragraph. What about changing as a result of a delusional belief to as a result of his delusional beliefs?
My preference would just be to take out the letter A and make beliefs plural, so it would read a result of delusional beliefs. I think using the word his under those circumstances makes it the sort of type of factual assertion that the cases have talked about being inappropriate. It's almost the court saying he had delusional beliefs. I think that, I don't object to making it a plural term, but I object to the word his.
Well, but I think saying of delusional beliefs implies the same thing. I mean, it's the same thing. Again, this is semantics now. And if I say, but he asserts that he did so as a result of delusional beliefs, well, obviously, this would be delusional beliefs that apply to him, and that's why he did this. That's what he's asserting. And I think it's clear that this isn't coming from the court. This is coming from him. This is what he asserts. So I'll grant the request. What's next?
And then also with respect to that sentence, we would ask that the court change the last part of the sentence that begins with the purpose of pursuing a psychotic delusion, etc. We would ask that the court change it to, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people. So the entire sentence then would read as follows. The defendant acknowledges that he engaged in planning and preparation, but states that he did so as a result of his delusional beliefs and psychotic thought process, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people. Does that make sense?
Yeah, I think he said states, but I've used asserts.
I'm sorry, yes, asserts.
Right.
That was our original request, was states, but
Right.
asserts.
Mr. Orman?
I don't have a problem with that, although I did notice something as counsel was reading that. I wonder if by changing delusional beliefs to plural, we've introduced, a grammatical anomaly, because it was a singular belief and psychotic thought process. And making that plural, I wonder if we either need to add the letter A before psychotic thought process or change that to processes. I'm not sure exactly what the assertion is, but I think that the way it's going to be written now, it reads wrong somehow.
Ms. Nelson?
I'm sorry, so the request would be to change...
You see where in the second line in the first sentence, the second line of the first sentence, it says now his delusional beliefs. Mr. Orman is saying that maybe we need to add an A psychotic thought process there, the letter A before psychotic thought process, or change psychotic thought process to psychotic thought processes. And I tend to agree with that suggestion.
We don't have a problem making process plural.
Okay, I'll make it processes, and then I'll make the other change. I think the other change is fine. So, give me just a second. So now that sentence reads as follows. The defendant acknowledges that he engaged in planning and preparation, but asserts that he did so as a result of his delusional beliefs and psychotic thought processes, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people.
Yes.
All right. What else?
Next, we would ask that the next sentence be made into a new paragraph. The previous sentence talks about planning and preparation, and then the following sentence talks about our theory for why he's insane. And so we thought it would make sense to separate that out and just make it a new paragraph.
So where it says the defendant maintains?
Yes.
Okay, Mr. Orman, any objection?
Your Honor.
Yeah, that's fine. What else?
And then with respect to that sentence, we would like to break it up into two sentences. So it would read as follows. The defendant maintains that his delusional belief system was born of his mental illness, comma, obscured his ability to make moral distinctions, comma, and rendered him incapable of understanding that his actions were wrong from a societal perspective of morality, period. The defendant further asserts that his delusional beliefs interfered with his ability to act with reflection and judgment concerning the charged offenses.
Mr. Orman?
Well, I don't mind that change, Your Honor. However, looking at this, I wonder if it's proper to say that it interfered with his ability to act with reflection and judgment, because the standard before the jury is, did it render him incapable of acting in that fashion? So it's almost an assertion, well, it's not quite rendering him incapable, but that's something that the jury should consider. It's not. They should not be able to argue an improper standard.
Not true, Your Honor, because the court is instructing the jury on lesser included offenses. And if the court recalls, that was my argument as to why we were entitled to lesser included offenses. And the jury can't be restricted to only evaluating whether or not Mr. Holmes was completely incapable of forming the culpable mental state. The Due Process Clause requires that the jury also be able to evaluate whether his whether his mental illness interfered with his ability to form that culpable mental state such that he would be guilty of a lesser included offense.
That's fine. Yeah, Mr. Orman.
That's wrong, Your Honor. I understand that the defendant does not like the fact that the legislature incorporated what used to be impaired mental condition into insanity and would wish it was not so, but they did, and that's the test. And I think what the jury can do and what the lesser included offense would acknowledge is they could say, well, okay, you know what? We would be insane for purposes of the culpable mental state for, let's say, after deliberation. So let's go on to the lesser, because that's a different culpable mental state that wouldn't be interfered with. But they can't just say, okay, it can be some touchy-feely, loosey-goosey means of diminishing his mental capacity in a fashion that is not in touch with the insanity statute. This is an attempt to go back to what we used to have before the legislature changed the statute, and that's why I say it's improper.
Well, I understand Mr. Orman's point. I do, and I think he has accurately stated the law. But this is not an instruction on the law. This is an instruction on what his theory of defense is, and he's not saying this is the standard. He wants to say that this is one of the things he's asserting in general, that people can get up in closing and explain, hey, look at what the standard is. Here's the law, and the law says that this is how you determine sanity. And then you can discuss the theory of defense instruction in that context. You can discuss the evidence in that context. Obviously, this does not substitute what I'm giving the jury as the law, and it would be improper for anyone to get up and argue that this is a substitute for the legal standard, or that as long as the jury is convinced of this last assertion, then they can find him insane. That would be improper. The jury has to follow the law that I give them. But I think in terms of what the defendant can assert in a theory of defense instruction, I don't think it's improper. So I'll make the last change. All right. Anything else with respect to this instruction, Ms. Nelson?
Then we would ask the court to consider including as the last sentence. I assume the court took some issue with the way that we had phrased the last sentence of our proposed theory of the case instruction, which was, our original proposed language was, but for Mr. Holmes' mental illness, the tragic events of July 20th, 2012 would never have occurred. And assuming that the court rejected that for a reason, we would ask that the court just include a final sentence. The defendant asserts that his mental illness caused him to commit the July 20th, 2012 shootings, or something to that effect. Again, as I said on Friday, this is absolutely a critical issue in this case. All of the psychiatrists who examined him gave testimony about the role that the mental illness played in the shootings, and for that reason, we think that's an important concept to include.
I did have some issues with that last sentence. I wasn't, the reference to tragic events, you can mention that in closing argument. I just don't think it's appropriate for a theory of defense instruction, but also the but for language. There has been testimony by at least a couple of experts about this, but there is a difference of opinion between the parties as to what exactly that means or what relevance that has. Dr. Metzner said this in his report, that but for Mr. Holmes' mental illness, the shooting would not have occurred, or something along those lines. Dr. Reed then said, well, duh, of course, and basically he took that to mean nothing. That's the way I read his report, and he said...
His testimony was different.
He, I think, was saying that but for Mr. Holmes moving to Colorado, this wouldn't have happened either. But for Mr. Holmes signing up for school, this wouldn't have happened either. But for a lot of things, this wouldn't have happened either. So I understood his testimony to be to minimize that, or to give that no significance or little significance. So I think this is more appropriate for closing argument. Now, in terms of whether you can say that mental illness is responsible, or was responsible, the defendant's mental illness is responsible for the crimes charged in this case, or something along those lines, that's different to me. So let me ask the people to respond to that. Mr. Orman, what's your response to the request for that last line?
It implies to the jury, Your Honor, that they are going to consider that question as a substitute for insanity, and it would be an instruction given to them by the court. There is no but-for test in the insanity statute in Colorado. The tests, I don't need to repeat them, we all know what they are. Those are the tests that the jury needs to consider, not this but-for Paul's graph sort of proximate cause thing. That's not the standard, and it's an improper assertion in variance with the law under the guise of a theory of defense instruction, so I object to it.
And again, Your Honor, it's clearly relevant. All of the experts testified to it. They didn't object to the question or the answers elicited from the experts. And so we would ask the court to include a sentence stating that his mental illness caused him to commit these charged offenses, or the July 20th, 2012 shootings. It's an integral part of our theory of the case. And I would just add that I make all of the objections and requested revisions, as well as our original theory of defense instruction that was proposed, pursuant to our right to present a defense, to due process, and to heighten reliability required in this capital case, pursuant to the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as Article 2, Sections 16, 20, 23, and 25 of the Colorado Constitution. And Ms. Higgs just pointed out to me as well that insanity does require, the insanity statute, Colorado's insanity statute does require mental illness, which is prong 1 of the test, as the cause for prong 2. So it's also relevant to the insanity determination for that reason. May I add something, Your Honor? Just
Hold
to make
on.
it clear. Okay.
Okay, Ms. Nelson?
I just meant to say, in other words, the statute requires, and the court incorporated this language over our objection, but it says care should not be taken to confuse mental disease or defect with something else. And so that, because of that language, I think it's clear that it's the mental illness that has to have caused the insanity or the inability to distinguish between right and wrong.
About something along the lines of the defendant asserts that his mental illness rose to the level of insanity on July 20, 2012, and that he is therefore not responsible for the crimes charged.
I don't think that gets at quite the same thing that we're trying to convey, so we would respectfully decline that proposal.
Well, I do worry about this confusing the jury or misleading the jury, because the causation is not the question. The question is, did he suffer from a mental illness that was so severe that it then rendered him insane, that it rendered him incapable of distinguishing right from wrong, or incapable of forming a required culpable mental state? So it isn't that, mental illness caused whether mental illness caused a crime or not. Mental illness may have been a cause of the crime, but that doesn't mean that he's insane. That's the part that I'm struggling with. I think that would be an incorrect statement of the law, and I don't want the jury to be misled. And I see this as different than the last sentence we talked about. The last sentence, I think it's a fair sentence in terms of what position the defense can take. I think the defense can argue, hey, his mental illness interfere, or his delusional beliefs interfere with his ability to act with reflection and judgment, because reflection and judgment are related to deliberation, and that's one of the mental states, the culpable mental states that's required here. But to argue that, well, but for the mental illness, or the mental illness caused the crimes, that's not the question before the jury. The question is, was there a mental illness? And if so, was it so severe that it rose to the level of insanity, such that he should not be held responsible under the law? So, Ms. Nelson, if you want, I will add the sentence that I just suggested or something along those lines, but I'm concerned about a proximate cause type of concept and adding that to the theory of defense instruction, because I think it's a misstatement of the law. If you want to argue it in closing argument, I think it's appropriate, but I don't think it belongs in the theory of defense instruction. Frankly, I think as it is, this theory of defense instruction, even without that language and without the suggested sentence that I just uttered, is complete, and it is appropriate, and it is fair. And as I said, I'm being generous. And frankly, I would have been justified in shortening this quite a bit. And I would have been justified in saying this is a two-line type of theory of defense instruction. And I'm erring on the side of caution and allowing more information in as much detail as possible to capture the essence of the theory of defense. But based on the case law, an argument could be made that some of this information should be, that I have in here should be taken out. But Ms. Nelson, I'll give you an opportunity to tell me whether you want the suggested language or you want something along those lines or something else.
Leave it as is, Your Honor.
Okay.
And could you remind me, so I can stick it back in my packet in the right place, when the court intends to give the theory of defense instruction
It's right before the insanity defense.
for the insanity?
I think it makes sense to put it right there. And then right after that, then the next instruction is the insanity instruction. It says the evidence in this case has raised the defense of insanity as a defense to all the charged offenses and lesser included offenses.
Okay, if I can just have a moment to
Yes.
reinsert it into my packet. Okay.
All right, any other instructions? Anything else that you want to talk about with respect to any of the other instructions?
Yes, Your Honor. So now I would like to discuss the proposed, the court's proposed changes to that last instruction regarding the verdict form, as well as the specific proposals that I submitted as part of D-292, which I understand that the court struck, but I'd like to make an oral argument in court.
Yes, you can make an oral argument.
So
let's take the last instruction first, or I guess that they're together, so you go ahead and discuss them
okay.
in conjunction with each other.
And I guess I just want to make sure that I'm making an adequate record about this, and that was my sole intention in filing these pleadings. And I would ask the court to reconsider the order it issued over the break in C-212, striking these pleadings. And if I could just explain, my understanding is that we are supposed, I understand what the court said at the beginning of the trial, that we're supposed to be making motions in open court. And we've done that, and we've done argument in open court, and I understand all of that. But I have to make sure that I'm providing Mr. Holmes with effective assistance of counsel, and that I'm complying with the ABA guidelines for the appointment and representation of defendants in capital cases, and that I am making as complete an appellate record as I can. And
you are. I'm giving you an opportunity to do it orally. The problem with doing it in writing is then I have an obligation to go look at it in writing, and I'm not going to have time today. It's 10 till 12. We have 165 verdict forms. I have 60 some odd pages of instructions. I have to finalize these. I have to make 24 copies of everything. Well, not all 165 verdict forms, but I have to make 5 copies or 4 copies of the verdict forms in their entirety. And it's not 164 because each verdict form has 3 pages, so it's almost 500 pages. And we're having closing arguments tomorrow. So by doing it this way at the last minute, it doesn't give me an opportunity to just to review it, to allow the people to file something in writing to respond, and to have me rule on it. So that's why we have to do it orally. We're here talking about it orally. If you make a request or if you make an argument or if you make some kind of record, I'm here right now and I can tell the prosecution, what's your position on that? And then I can rule. And then if you have another record to make or another position to make, then you can make it and I tell the prosecution, what's your position on that? And then I rule on it. And that way the record is complete. But to do it any other way, then creates a record that is unclear and a record that is dangerous on appeal, because then what it looks like is all these records and arguments that you may have made in your written filings that I did not have a chance to review, and yet someone on appeal will say, well, the record was preserved, the judge just didn't rule on it. And that's not accurate, and that's not appropriate. So if you have something to say, bring it up with me right now. I'll give the prosecution a chance to respond, and I'll rule on it. But you can't just file something just to have it on file. We have had now, this is the 3rd jury instructions conference. You've had my draft, the draft that I gave you on July 2nd. You had that one for 8 days before we talked about it on July 10th. So you had plenty of time to look at it, to consider that draft, to figure out what else you needed to file. I did not limit you in terms of what tendered instructions you submitted either before the first jury instructions conference on June 24, or before the last one on July 10. But to come in today when I'm expecting to just finalize the instructions and have a voluminous filing with new tender instructions, that's not appropriate, especially when the pleading that is attaching or that has attached all those new tendered instructions appears to have some record made about different things. I can't, that's just not a good way to proceed. So we have to do it this way. So make your oral record, and then I'll give the people a chance to respond, and then I'll rule. So with respect to this instruction, my recollection with respect to the last instruction is that your main concern had to do with the issue in Bielecki and Collins and the statute that I cited earlier. And I changed it over the weekend. Of course, you didn't know that because I did it over the weekend, but I changed it in accordance with what I felt was your concern. I'm not saying that you've waived anything, but to the extent that you've submitted newly tendered instructions that address that issue, I believe the issue has been addressed. And that's another problem with submitting things without getting leave of court, is that you're submitting something, and yet I made a change. If someone sees the two, they're not going to get what's going on. They're going to be confused when someone's reviewing the record. And so I think this is the clearest and cleanest way to go. The changes I made is to make clear to the jury that they are to consider the evidence and the law separately and independently with respect to each count. I've repeated that concept that was already in an instruction. I've repeated it in the last instruction. I've reminded the jury of it. And I've said to the jury, so even if you find him guilty of one count, that doesn't mean you have to find him guilty of any other count. And even if you find him not guilty of one count, it doesn't mean you have to find him guilty of another count. And that applies even if the reason for the not guilty finding is solely based on the prosecution's failure to prove beyond a reasonable doubt sanity. That's all in there now. I've also added the parenthetical information that you wanted, reminding the jury what Part B of each verdict form is about and what Part C, well, I did Part C on my own just to be consistent. But so I did all that based on the discussion that we had Friday. So as constituted, what is your position on this last instruction?
We don't, as constituted with respect to the last instruction, I don't have an issue or a problem with what the court added. However, it doesn't cure the constitutional problems that I see with the instructions in the verdict forms in general. And I would like to explain why to the court, if I may.
Yes.
And in doing so, I may read directly from D-292 just to make sure that I'm articulating myself clearly.
Just as long as you read slowly so that my court reporter can follow along and I can follow along.
I will, Your Honor. Just to put this into context, just to explain to the court where I was coming from and why I proceeded in the fashion that I did. Our original position before the charging conference that we had on Friday, July 10th, and was and continues to be that the verdict form separated out into a Part A and a Part B, setting aside the issue of whether the jury completes Part B for every count or not, is that the court's draft verdict form, which provides the jury with only two options, guilty or not guilty, in Part A of the form, and then proceeds to inquire about the basis of a not guilty finding in Part B of the form, violates Mr. Holmes' state and federal constitutional rights to due process and a fair trial by an impartial jury under the 5th, 6th, 14th Amendments to the United States Constitution, as well as Colorado Constitution, Article 2, Section 25, as well as the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, because the verdict form does not clearly convey to the jury that it has the third option of finding Mr. Holmes not guilty by reason of insanity, and thus enhances the risk of an unwarranted conviction under Beck versus Alabama.
All right, let's take it one by one. So the people want to respond to that. We've talked about it, but anything that the people want to add with respect to that issue?
I think we adequately covered that on Friday.
I think so too. And I'll repeat again, I am bound by Colorado law. This is what Colorado law specifically requires me to do. This is how the model instructions suggest that I do it. I'm doing it consistent with Colorado law and the model instructions, and so I incorporate by reference the record we made on Friday with respect to this particular issue. Okay, what's next?
Okay, so that was our position going into the charging conference on Friday, that our proposed verdict forms, which give the jury just three simple separate options, not guilty by reason of insanity, or guilty, are required by due process and the other constitutional provisions that I just cited, including heightened reliability under the 8th Amendment, Article 2, Section 20 of the Colorado Constitution. Under the 8th Amendment and Article 2, Section 20 of the Colorado Constitution. So after it became clear that the court disagreed with that position that we took on Friday, excuse me, hold on one moment, and continue to take, then we moved on to discussing the second issue and concern that we have with respect to the verdict forms, which is that the jury only fills out Part B of the verdict form if they find Mr. Holmes not guilty of all of the counts. And so it was in relation to that discussion that I was concerned that things got a little confusing and that I didn't provide specific enough direction and request in terms of what we were asking for. And so that's why, after reflecting on the conference that we had over the weekend, I thought it would be prudent to give the court very specific language about that addresses the issues that we have remaining with the verdict forms.
But you've had these verdict forms since July 2nd, and I specifically made a record about this issue on July 2nd and told you both that I was doing it this way because it's required by Colorado law, and said Bielecki requires it, Collins requires it, and 16-8-105.5 subsection 3 requires it. So even though we had not actually had a discussion about it until Friday, July 10th, I had already told you that this is the way I was doing it and why. I had told you I'm doing it this way because I'm required by law, and you both looked surprised, and I gave you the authority so you could go look at it. So to the extent that you wanted to file any tendered instructions, they should have been filed on July 10 when you filed the other second set of tendered instructions that you filed. But at this point, I'm more interested in moving on. I mean, I have ruled that we're going to proceed orally, and I have explained why, and I think anyone reviewing this record will understand why I'm doing it this way. I think it's the cleanest way. It's the only way to do it, and the cleanest way. It's the only way to do it in order to have a clean record and a record that's clear. So in terms of the point about the jury only filling out Part B of the verdict forms, if the jury finds the defendant not guilty of all the charges and all the lesser included offenses, that's pursuant to Bielecki, Collins, and 16-8-105.5 subsection 3, and I incorporate by reference the comments that I made on July 2nd and on July 10. What's next?
Okay. If I can just make an additional oral record about this.
Yes.
And the reasons why we are concerned about the way that the draft verdict forms and instructions are written. We're concerned that they direct a verdict on all counts as to the issue of sanity in violation of Mr. Holmes' state and federal constitutional rights to due process and trial by jury, as well as the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, because the instructions and verdict forms effectively convey to the jury that a finding of not guilty by reason of insanity is an all-or-nothing proposition, and that a finding of guilty on any one count negates the possibility of finding Mr. Holmes not guilty by reason of insanity on any other count. And if the instructions and the verdict forms are given to the jury as they are written, the jury will have the impression, notwithstanding the edits that the court made to the instructions over the weekend, that it is precluded from being able to return a not guilty by reason of insanity verdict on appropriate counts, and instead must choose only between guilty and not guilty verdicts unless it finds the defendant not guilty by reason of insanity on all counts, which also increases the risk of an unwarranted conviction under Beck versus Alabama. And then separately and additionally, given the facts and circumstances of this capital case, it is constitutionally necessary for the jury to complete Part B of the verdict form for each count, regardless of its verdict on any other count, so that the jury can give full effect to its verdict on each count. I would note that the rationale under Bielecki and Collins is that it is unnecessary for the jury to complete the special interrogatory on insanity, which is Part B of the verdict form, if a defendant is found guilty of any of the felony counts, because a guilty verdict on any count subjects the defendant to incarceration in the Department of Corrections, and the jury's reasons for finding him not guilty on any other charge are no longer important. But the distinction is that in this capital case, that justification is subordinate to the jury's need to render a full and complete verdict on each individual count for purposes of evaluating whether Mr. Holmes should be sentenced to death. In addition, the Colorado Supreme Court must review the propriety of any death sentence, and the propriety of any death sentence will necessarily require an evaluation of the actual verdicts rendered on each count. And the jury's actual verdict on each count is likewise necessary to assess the reliability of any death sentence that could potentially result in these proceedings, and therefore a complete and accurate verdict form for each count specifying whether the jury has found Mr. Holmes not guilty or not guilty by reason of insanity is required by the Eighth Amendment in Article 2, Section 20 of the Colorado Constitution. And I would cite to Beck, People versus Young, 814 P. 2nd, 834, Colorado, 1991, as well as People versus Tennyson, 788 P. 2nd, 786, Colorado, 1990. And I would also just note that neither Bielecki, Collins, nor the statute appears to have contemplated the type of charges that we have in this case, which include multiple Class 1 and Class 2 felonies of first-degree murder and attempted first-degree murder, as well as a single Class 4 felony of a different nature that was allegedly committed at a different time and location, which is the possession of the explosives or incendiary devices. And so if the jury were to find, hypothetically, Mr. Holmes guilty of the explosives count, which is a Class 4 felony, and not guilty by reason of insanity on the murder and attempted murder counts, but didn't specify in Part B whether or not its not guilty verdict was based on a finding that Mr. Holmes was insane, Mr. Holmes would be sentenced to the presumptive range of 2 to 6 years on the explosives count and then released into the community. Whereas if the jury were to make the same findings and did complete Part B for each count, then presumably following any sentence of incarceration that he serves on the Class 4 felony, he would be or could be committed to the Department of Human Services as a result of the not guilty by reason of insanity verdicts on the Class 1 and 2 felonies. And so it does matter in this case, just given the way that the charges have been laid out. And in fact, that was precisely the result in the Eastwood case that I mentioned on July 10th on Friday. He was acquitted of the greater accounts and convicted of a lesser account and was sent to the state hospital because he had received credit for time served on the lesser charge that he was found guilty of. I don't mean greater and lesser as a lesser included. I mean there was a more minor felony charge as well as greater felony charge. So that's the basis for the proposed changes. And if I can quickly just put on the record what those proposed changes are. And I again would object to doing this orally only because I think it's important for an appellate court to be able to see precisely how we're asking to amend these instructions so that it's to avoid confusion for the appellate record. But understanding the court has denied that request, I will proceed orally. The first would be to the elemental instruction on murder in the first degree after deliberation. Our request would be to make the following additions to the last paragraph. It currently reads, after considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, and then we would add, including element 7, which pertains to the defendant's sanity, you should find the defendant not guilty of that count in murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. So that actually the court, even if the court disagrees with my position about having the jury fill out Part B of the verdict form for each and every count, I think the court can and should add that language into each elemental instruction to make it clear that how they give effect, how the jury should give effect to a not guilty by reason of insanity verdict.
So you want me to add, including element 7, which pertains to the defendant's sanity?
Yes.
Okay. All right, and to the extent that you're asking me to make the same change in other instructions, you can just say, make the same change in instruction blah, 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 so you don't have to repeat everything.
Okay, will
Okay?
do. And then,
By the way, once we've gone through them, then if you want to submit them in written form, you can. All you have to do is ask for leave of the court, and I will grant you that request. Of course, I understand that anyone reviewing this record on appeal would want to have them in writing, but I want to make sure that that's the only difference between the tendered instructions that you're talking about now and the ones that I have received in the past, because I'm not going to have a chance to review these today, given that I have to finalize the instructions and make all the copies and get ready for tomorrow for closing arguments. Does that make sense?
that does make sense, Your Honor. And given, and I can tell the court too that,
But when you file them, by the way, I apologize, Ms. Nelson, when you file them, I don't need a pleading explaining anything. Just file them. All I need is a one-liner saying, here are the additional tendered instructions that the court gave us permission to file pursuant to the discussion we had on July 13th. I'm not asking for any other record, argument. The time to make records and argument is here while we're all here talking because of the time limitations that we have. Okay, go ahead.
I understand that, Your Honor. Actually, I was just going to say that one of the reasons that I did put into writing what our objections and concerns with the verdict forms are is because having done a lot of appellate cases, I wanted to make sure that for an appellate court or any appellate attorneys who are reviewing the record, it's just not totally out of context or they're confused about what this is, because sometimes you review the record separately from the transcript and it's not immediately apparent like how the two connect. And so I would ask the court for permission to just refile this now that I've essentially read it into the record, just so that someone who's looking at the appellate record later understands what this is and why, what its purpose is.
No, you can refile the instructions themselves. To the extent that you've made the record, we've talked about that record here, and we're still talking about the record. So to the extent that that pleading includes any assertions or arguments or requests or records or any commentary, I am reacting to it here after I give the prosecution a chance to respond. So they can read the transcript. I'm sure those folks are equally good and adept at reading transcripts as they are motions. Now, to the extent that you want to submit the actual instructions, if you're representing to me that the only difference between the ones you're submitting now and the ones you've submitted before is the language that you're referencing now, then I will take you at your word and you can resubmit them after we have had the discussion here. So go on. What other instructions are you asking me to add that language to?
So I would ask, well, first I have one additional sentence that I would request that the court add to the end of that paragraph in the elemental instruction that states, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on the defense of insanity. I understand that the court is likely to reject that language based on the court's position regarding Bilecki and the statute, etc., but that's the request that we would make. So just to summarize, to make it clear, the last paragraph, there are two modifications that we're asking for. The first would be to state, including element 7, which pertains to the defendant's sanity, in that first paragraph, discussing whether what the jury should do if it finds the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt. And then the second change would be to add that sentence that I just stated. You should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on the defense of insanity.
Okay. What other instructions are you asking that these changes be made to?
Okay, so that change applies to the elemental instruction on first-degree murder after deliberation. It also applies to the elemental instruction on the lesser included offenses to murder in the first degree after deliberation. It also applies to the elemental instruction on murder in the first degree extreme indifference. as well as the elemental instruction on the lesser included offenses for first-degree murder, extreme indifference. It applies to the elemental instruction with respect to the charges of attempt to commit murder in the first degree after deliberation, as well as the elemental instruction on the lesser included offenses of attempt to commit murder in the first degree after deliberation. It applies to the elemental instruction on the offense of attempt to commit murder in the first degree extreme indifference, as well as to the elemental instruction pertaining to the lesser included offenses of attempt to commit murder in the first degree extreme indifference. It also applies to the elemental instruction on count 141, which is possession or control of an explosive or incendiary device, and the elemental instruction on that.
Okay, great. All right, do the people want to respond?
We object, Your Honor. We think the instructions as currently constituted accurately depict the law or describe the law, and these would not.
Well, I've made an extensive record on this point already, both on July 2nd and July 10th, as well as today. And I had to follow the law, and the law in Colorado is clear. Let me read to you from Colorado Revised Statute, Section 16-8-105.5, subsection 3. When the affirmative defense of not guilty by reason of insanity has been raised, the jury shall be given special verdict forms containing interrogatories. The trier of fact shall decide first the question of guilt as to felony charges that are before the court. If the trier of fact concludes that guilt has been proven beyond a reasonable doubt as to one or more of the felony charges submitted for consideration, the special interrogatories shall not be answered. Upon completion of its deliberations on the felony charges as previously set forth in this subsection 3, the trier of fact shall consider any other charges before the court in a similar manner, except that it shall not answer the special interrogatories regarding such charges if it has previously found guilt beyond a reasonable doubt with respect to one or more felony charges. The interrogatories shall provide for specific findings of the jury with respect to the affirmative defense of not guilty by reason of insanity. So this statute requires me to give the jury special interrogatories or special verdict questions asking them if the reason that they found the defendant not guilty is based on the insanity defense or not. But it also tells me that I have to tell the jury that the jury should not answer those questions, should not answer any of those interrogatories if they find them guilty on any felony charge, and that the way that the jury should proceed is that the jury should first decide guilty or not guilty, in other words, the issue of guilt, with respect to all the felony charges, and that the jury should only get to the interrogatory or to the special verdict form, if you will, the special verdict question, if you will, if and only if they find the defendant not guilty of everything. That's what I'm doing. I don't have a choice here. I took an oath to uphold the law, and there's no exception in the statute to a case where the prosecution is seeking the death penalty. There's no exception in the statute at all. The statute says this is how we have to proceed, and I'm proceeding pursuant to the statute. Furthermore, there's a case from the Colorado Supreme Court, People versus Collins. I've cited it before, that says this is how I have to do it. There's a case from the Colorado Court of Appeals, People versus Bailecki, that says this is how I have to do it. I have to follow the law. I'm following the law. Oh, and one more thing. The model instructions, which are there to provide guidance to the trial court, says this is how you should do it. I'm doing it consistent with all those authorities and consistent with the model instructions. And, you know, if counsel, based on the concern expressed by Ms. Nelson, I added some language to the last instruction to repeat the same thing that a different instruction already talked about. And we already had an instruction on multiple counts. The multiple counts instruction already tells the jury that there are multiple counts in this case, and explains to the jury that a separate offense is charged against the defendant in each count. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. The fact that you may find the defendant guilty, not guilty, or not guilty by reason of insanity of one of the charged offenses should not control your verdict as to any other charged offense against the defendant. The defendant may be found guilty, not guilty, or not guilty by reason of insanity of any one or all of the charged offenses. This is not a case where I have included the type of language that was problematic in Bailecki and that led the defendant to argue that it was essentially a directed verdict, or that it called for a directed verdict. I have avoided that type of language. Not only have I avoided the type of language that the trial court included in the instructions in Bailecki, but I have actually gone out of my way to make it clear to the jury that there is a difference between, on the one hand, being able to find the defendant guilty, not guilty, or not guilty by reason of insanity with respect to any count, and on the other, us only caring about the reason for the not guilty verdict if they find him not guilty of everything. And so, you know, on the one hand, it's clear, and by the way, in the final instruction, it's even more specific, because there I have made it more detailed, more specific with respect to including the lesser included offenses. The language there is, therefore, the fact that you may find the defendant guilty of the charged offense or a lesser included offense in a count should not control your verdict as to the charged offense and lesser included offenses in any other count. Similarly, the fact that you may find the defendant not guilty of the charged offense and the lesser included offenses in a count should not control your verdict as to the charged offense and the lesser included offenses in any other count. This is the case even if the reason that you find the defendant not guilty of the charged offense and the lesser included offenses in a count is solely based on the prosecution's failure to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. That language addresses Ms. Nelson's concern about a directed verdict, or her concern that the jury is going to think that in order to find him not guilty by reason of insanity of any count, they have to first find him not guilty by reason of insanity of all the counts. That language takes care of that concern. Now, having said that, then the next paragraph explains to the jury, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard Part B of all the verdict forms. That language is going at what they should fill out and what they shouldn't fill out, not what they should find or can find or should not or could not find. That's the distinction. We only care about the reason for a not guilty verdict on a particular count if the jury finds the defendant not guilty of all the charged offenses and all the lesser included offenses. But that doesn't mean that if the jury is an all or nothing proposition in terms of what the jury can find in this case. So for all those reasons, and by the way, counsel, as I've said before, can explain this in closing argument, and they can clarify it. You know, counsel are entitled to provide comment on the instructions. The instructions don't need any clarification. But if counsel believe they need to make sure the jury is clear on this, they can get up and talk about it as long as what they say is consistent with the instructions. So, for all those reasons, I continue to believe that the instructions as constituted are appropriate and the request is denied. Ms. Nelson, what else?
Next would be a proposed change to the instruction about the affirmative defense of insanity. And I should make clear, if it's not already clear, that the changes that I'm proposing right now are these are additional changes that are based only on this verdict form issue, and I'm not waiving any objections or proposed changes that we've previously discussed at the other two charging conferences.
Okay.
It's on page 3, and it's at the end of that at the end of the paragraph that
The last paragraph of the...
spills over from page 2 onto page 3. So it says, if you decide that the prosecution has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act alleged in a charged offense and in its lesser included offenses, you must find the defendant not guilty of that charged offense and of its lesser included offenses. In that event, you should have the foreperson sign on the designated line in Part A of the verdict form for that count to indicate your verdict on that count. And then our proposed additional language would be, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on solely based on the defense of insanity.
Okay. Do the people want to respond?
Objection, Your Honor.
All right, same objection, same ruling. Again, it's going to be clear later, not only in the instructions, but in the verdict form as to when they fill out Part B of any verdict form. And that is, they either fill out Part B of all the verdict forms, or they fill out Part B of none of the verdict forms. What else?
So the next instruction is that we are proposing changes to is the one that starts out, I think it starts out, if you find the defendant not guilty of all the charged offenses and lesser included offenses, you should answer the following verdict question in Part B of the verdict form for each count.
No, it starts out with, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard the remainder of this instruction as well as Part B of all the verdict forms.
Right, yes, that's the one I'm talking about.
Okay.
The reason I got confused is because our proposal is to omit that first paragraph. So our proposed revision would be to omit that first paragraph, and then in the second paragraph, take out the word however, and change all to any of. So it would read, if you find the defendant not guilty of any of the charged offenses and lesser included offenses, you should answer the following verdict question in Part B.
Okay, do the people have a position?
Object.
Same objection, same ruling, same issue. This is by Leckie, Collins, and the statute that I read from a moment ago, 16-8-105.5, subsection 3.
And then the final instruction, and then I have proposed revisions to the verdict forms as well. The final instruction would be the instruction that states following the parties' closing arguments.
Yes.
And then, so we would ask the court in the third paragraph where it says, you should indicate your verdict on each count in Part A of the verdict form. If you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, we would ask the court to include the following language, including element 7, which pertains to the defendant's sanity, then your verdict on that particular count is not guilty, and you should have the foreperson sign on the designated line in Part A of the verdict form. And again, this edit or this requested revision, I don't think it conflicts with the court's position on the Bilecki issue, but it just makes it clear how they give effect to a not guilty by reason of insanity verdict.
By saying including element number 7.
Yes.
All right, Mr. Orman.
I don't think that's necessary, Your Honor. I think the instruction that is currently constituted accurately conveys the duties of the jury.
I agree, and furthermore, I think it highlights one element over all the other ones, and I don't think that's appropriate. So
And then the next
request is denied.
Sorry. May I proceed?
Yes, go ahead.
And then on the second page, we would ask the court to omit that paragraph that begins, if you find the defendant guilty of any charged offense or lesser included offense, you should disregard Part B of all the verdict forms. So we would ask to omit that entire paragraph and instead add a paragraph that states the following.
Are you on the old draft or the new draft?
Oh, I'm on the old draft.
Okay.
That's why. I'm
Well,
on
the
old
new draft reads differently than the one you're working off of now.
Let me-
So the
let
last
me-
paragraph that you read also didn't track the new draft, just FYI.
Okay, let me pull out the new draft. I think I can,
Because on the last one that you just, let's go back to your request to add including element 7 or something along those lines. Which paragraph is that on?
let me look at I'll look at the new draft and then
Okay.
we can work from the new draft. So the new draft, it would be, no, it would be the same, actually, for that first change.
It's the third paragraph, right?
Mm-hmm.
And then which sentence? Second sentence? If your verdict on account is
Verdict on
not
a-
guilty of the charged offense and the lesser included offenses, you should have the foreperson sign on the designated line in Part A of the verdict form for that count. That's the sentence where you want to add that including element 7 language?
Yes, and I guess we would ask that it be phrased in terms of the prosecution failing to prove any one or more of the elements beyond a reasonable doubt. So it would read, you should indicate your verdict with respect to each count in Part A of the verdict form. If you decide the prosecution has failed to prove, and then instead of the sentence that the court has in the new draft, it would read, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, including element 7, which pertains to the defendant's sanity, then your verdict on that particular count is not guilty, and you should have the foreperson sign on the designated line in Part A of the verdict form for that count.
And so then the next line, are you proposing to change it so that it reads, if you decide that the prosecution proved beyond a reasonable doubt all the elements, then your verdict is guilty?
That would be fine.
Okay, yeah, I don't think it's necessary, so my ruling stands. I think that that point is made throughout these instructions, and this last instruction is just talking about, in general, how to fill out the verdict forms. So,
Okay.
what else?
So then on the second page, I don't have an objection to the paragraph the court added that begins as mentioned earlier in these instructions. So I don't object to that addition.
Okay,
But I continue to object to the next paragraph that begins, having said that, if you find the defendant guilty of any charge, blah, blah, blah.
okay.
So instead, I would ask that instead of that paragraph and the paragraph that follows, that the court omit those two paragraphs and instead include a paragraph that states, if you find the defendant not guilty on any count, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on that count solely based on the defense of insanity.
People's position,
Object.
right? Same objection, same ruling, same issue under People versus Bielecki, People versus Collins, and Colorado Revised Statute Section 16-8-105.5, subsection 3. What else?
And then, working from the new draft, it would be the third page of the instruction. The final paragraph that begins, if you conclude that the verdict question in Part B of all the verdict forms should be answered, we would ask the court.
Wait, where are you? I'm sorry.
I'm sorry, it's the last paragraph of the third page of that instruction.
That starts with, you will be provided with 165 verdict forms?
No, the page before that.
Oh, sorry. If you conclude that paragraph?
Yes.
Okay, go ahead.
We would just ask the court to change of all the verdict forms to of any of the verdict forms
Okay,
for the same reasons that we've previously stated.
all right. The people's position?
Objection.
All right, same issue, same ruling, same objection, same ruling, again, under People versus Bielecki, People versus Collins, and Colorado Revised Statute, Section 16-8-105.5, subsection 3. What else?
Okay, that's it for the instructions.
Okay?
And then with respect to the verdict forms,
All right, let me get those, hold on. All right, let's work on the newest, on the most recent draft that we distributed this morning. All right, go ahead.
let me just make sure that there aren't any differences between the drafts that I was working from and this draft.
There may be differences that are, in my view, not substantive.
So the requested change would be, instead of, if you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all of the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. We would propose or request that it be changed to read, if you found the defendant guilty of the charged offense or a lesser included offense in this count, you should leave Part B of this verdict form blank. If, however, you find the defendant not guilty of the charged offense and lesser included offenses in this count, you should answer the verdict question below, which would give effect to our request that the jury fill out complete Part B for all of the counts, regardless of whether they found him guilty on any other count.
The people's position?
We object.
Same objection, same ruling. It's the same issue. It's Bielecki, it's Collins, it's Colorado Revised Statute, Section 16-8-105.5, subsection 3. And the record will reflect, by the way, that Ms. Nelson's position is consistent with the way I had initially drafted the instructions in the verdict forms. And then I after researching it further, concluded that I was wrong. And I corrected it based on Bielecki, Collins, and 16-8-105.5, subsection 3. And then I also concluded that this is consistent with the model instructions, which my first draft of the instructions was not. It was not consistent with the model instructions. And so, just for the record. All right, what else, Ms. Nelson?
And just for the record, Your Honor, our position is that this breaking the verdict form into, we continue to maintain our objections to breaking the verdict form up into Part A and Part B in general, and we continue to maintain that the only constitutionally compliant way to do it is to do it the way that we proposed, but I'm making these proposed changes based on my understanding the court has rejected that request.
Yes, and I have done it based on the authority that I have cited, Bielecki, Collins, and 16-8-105.5, subsection 3. The statute, I read it a moment ago, specifically tells me to proceed in this fashion. It specifically says, Judge, you need to break it down into two. One part of the verdict form needs to just address guilty or not guilty. And then there should be a question or interrogatory that's separate. And in that question, the jury should be asked, if you found the defendant not guilty, is the reason you found him not guilty solely based on the prosecution's failure to prove beyond a reasonable doubt his sanity? And that's the way I've done it. So what else?
And that is it, Your Honor, with the understanding that our request regarding Part B of the verdict form applies to all of the different verdict forms on all of the different types of counts that were included in the court's proposed draft verdict forms.
Got it. That's all 165 verdict forms.
Yes.
Okay.
Yes.
Anything else?
Just one more thing, and this relates to the pleading D-291 that the court also struck. And just to be clear, the only reason I included this language in the pleading that these renumbered instructions were attached to was to make sure that I was constitutionalizing everything and preserving everything with respect to Mr. Holmes' constitutional rights with respect to these jury instructions. And so if the court has decided to strike that pleading, I would just request an opportunity to state orally the constitutional provisions that we're proceeding under, as well as just to make sure that I'm making all of the arguments that I need to be making with respect to the jury instructions globally.
I have stricken D291, so I am not considering it. I have not, that's not part of the record. So any record that you want to make it orally now, and I'll give you an opportunity to do that. Every opportunity that you want, I'll give it to you. So
Okay.
no time limit. You make whatever record you want to make. To the extent you make any requests, I'm going to ask the prosecution to take a position, and then I'm going to rule on it. So go ahead.
So for the record, I would just like to state that we have submitted all of the jury instructions that we have submitted thus far at this point in the case pursuant to Mr. Holmes' state and federal constitutional rights to due process, a fair trial by an impartial jury, his right to counsel, and the right to a fair and reliable sentencing proceeding as protected by the 5th, 6th, 8th, and 14th Amendments in Colorado Constitution, Article 2, Sections 16, 18, 20, 23, and 25, that we maintain our request that the court inform us of any specific objections to incorrect or poorly drafted portions of instructions and assist us in drafting correct substitute instructions. That
Hold on, let's take that one at a time. You said that you maintain your request that the court inform you of any specific objections to incorrect or poorly drafted portions of the instructions and assist you in drafting correct and substitute instructions. I don't remember you making that request before, but
we did make it with respect to the theory of defense instruction.
okay, well, that's with respect to that instruction. It's one thing to say we might maintain our record with respect to our theory of defense instruction. It's another thing to say we maintain our record with respect in general to any objection. First of all, the court doesn't make objections, so I'm not sure what that refers to. But secondly, the court is under no obligation to specify for you anything. We've had a conversation about instructions. When there was an instruction that you proposed, we discussed it. I addressed any reasons that you stated on the record. I addressed any objections that there may have been by the people. When there was an instruction that was included in my draft, we addressed it. I gave you every opportunity to address whatever was in my instruction, whatever objections you had, and whatever arguments you wanted to make, whatever suggestions you wanted to make. And I gave the people an opportunity to be heard in that too, and I ruled on it. So to the extent that you're maintaining the record that you made with respect to the theory of defense instruction, I understand that, and you are maintaining that record. To the extent that this refers to something else, I'm not sure I follow you. So which is it? And if it's something else, then I need to know more about it.
I think we can move on, Your Honor.
Okay, so you're making this record with respect specifically to the theory of defense instruction?
And also based on my previous recollections of arguments that I have made orally, but I understand that the court may not have the same recollection that I do.
Well, I don't remember, but to the extent that you've made it, what exactly is it that you're asking of the court?
Well, I don't have anything further to say on that point, Your Honor.
Okay, do the people have anything on this point?
No, Your Honor.
Okay, without anything else from defense counsel, we'll move on. What's next?
Just that we continue to move this court, or ask that the court, I should not say that, I should say, we ask the court to instruct the jury completely and accurately in language understandable to the average juror on all of the issues presented by this case. And we assert Mr. Holmes' rights to trial by jury and to due process under the 8th Amendment to complete and accurate jury instructions on all legal principles involved in this case. And we incorporate these constitutional provisions as support for every jury instruction we have tendered. And that's it.
Any response from the people?
Sounds like that's just a request for accurate jury instructions, which I think is what we have.
Yes, I have done my best to make sure that the instructions are complete and to make sure that the instructions are accurate. To the extent that either side has disagreed with me, I have listened to both sides and given both sides an opportunity to tell me specifically what parts of the instructions they think are inaccurate or what parts of the instruction they think are incomplete. To the extent that this is a request related to the information in the instructions being understandable to the average juror, again, these instructions are based on my understanding of the law, and they are in general consistent with the model instructions. To the extent that counsel believes there's anything in these instructions that is not clear or that would not be understandable to the average juror, then they have an obligation to tell me about that specifically. I've given them every opportunity to do that, and I have addressed every request that has been made, every objection that has been made, and every argument that has been advanced. And without anything more specific than that, there's nothing else I can do to address that point other than to say I've done my best to draft the instructions to make sure that they're accurate, complete, and understandable. But to the extent that either counsel on either side disagree or have any concerns, they have an obligation to point that out to me, and I have asked them to do that, and I believe they've done that to the best of their ability. If there's anything else that anyone wants to point to specifically, now is the time to do it. Is there anything else specific that the people want to point to that is either inaccurate, incomplete, or not understandable to the average juror?
No, Your Honor.
All right, Ms. Nelson, anything else that you want to point to with respect to any part of the instructions that you believe is inaccurate, incomplete, or not understandable to the average juror? Anything else than what we've talked about?
May I have just a moment, Your Honor?
Yes.
One more thing to put on the record.
Yes.
And it pertains to the language that we asked for in the first two paragraphs of the lesser included offense instructions, that the language that we proposed essentially conveys to the jury that they do not need to, that the law doesn't restrict the order in which they consider the offenses. And Mr. Orman made a comment on Friday that that there's a statute that was contrary to what we had articulated in the language in our proposed jury instructions, and I just wanted to put on the record I was not able to find any such statute that conflicts with the language that we proposed. I think what Mr. Orman may have been referring to was section 18-1-408 subsection 8, but I don't think that statute makes Colorado a hard transition state instead of a soft transition state. I think it's clear that the language that we proposed in our submitted lesser included instruction is an accurate statement of the law, and the cases that I cited in the sources section of that proposed instruction are still good case law in the state of Colorado. So I just wanted to make that additional record on that point.
That section that Ms. Nelson just cited, Colorado Revised Statute Section 18-1-408, subsection 8, reads as follows: without the consent of the prosecution, no jury shall be instructed to return a guilty verdict on a lesser offense if any juror remains convinced by the facts and law that the defendant is guilty of a greater offense submitted for the jury's consideration, the retrial of which would be barred by conviction of the lesser offense. Was that the statute that you were referring to, Mr. Orman?
That was, Your Honor, and my recollection of the request from the defendant was that the jury be instructed that they don't have to be unanimous on a greater offense if they can be unanimous on a lesser one. In other words, if there was a disagreement, 6-6 or something like that, to acquit and to convict on murder in the first degree, well, then they should just go to, they can still consider the lesser offenses. That's just not the law. This case, the statute indicates that. That is what the legislature has said. So I maintain my position.
And I maintain my ruling. My ruling was that the instructions as constituted on the lesser included offenses are consistent with Colorado law, and I continue to believe that that's the case. And by the way, they are consistent with the model jury instructions, the criminal model jury instructions as well, which were just published last year. So that request is denied. All right. Is there anything else then that we need to talk about with respect to the instructions from the people?
No, Your Honor. Do you have an estimate as to when we might get a Word draft of this? I'm not talking about all of the verdict forms, but of the modified instructions.
Probably within the next couple of hours is my hope.
Thank you, Your Honor.
Okay. Or maybe within the next hour. I suppose that the ones that you're asking for do not need the blanks filled in, so we could email those pretty quickly. All right. Anything else on behalf of the defense, Ms. Nelson, with respect to the instructions or the verdict forms?
No, Your Honor.
And what I'll do is, once I have them done, we'll email them to both of you. And then once I have the blank spaces filled in, we will have copies for you, and we'll give you those copies tomorrow morning. The order that I intend to put the instructions in is the order that the last draft is in, other than what Ms. Nelson asked for, and that is to move the definitional instruction. So I will move it as I indicated that I would. But otherwise, the order is going to be that, and then the verdict forms, they're just going to be a lot more of what I have shown you. I have shown you, and we've talked about sample verdict forms, 5 sample verdict forms. And there will be a record of it because we're going to put them in the file as well. There are 5 because there are 5 types of charges. We have murder in the first degree after deliberation charges, murder in the first degree extreme indifference charges, attempt to commit murder in the first degree after deliberation charges, attempt to commit murder in the first degree extreme indifference charges, and then the possession or control of an explosive or incendiary device charge. So 5 different types of verdict forms. And those are the ones that we've been working with in terms of the sample forms. Those are the ones we're going to distribute to the jury tomorrow, and that I'm going to go through with the jurors tomorrow morning. But I will finalize and create 165 verdict forms. There are 3 pages to each verdict form, as you know, except for the last one, which only has 2 pages. So we're going to make a copy of all 165 for each party, and then we'll have a copy for the court file as well. Okay? Ms. Nelson?
I just wanted to ask permission for leave of court to refile D-291 and D-292 consistent with the parameters established by the court.
Yes, you can file the number instructions and renumbered instructions, as I discussed. I think 291 is just a renumbering of the first set of instructions, and then the numbering of the second set of instructions that you tendered. Is that correct? Or maybe
yes. Well, I wouldn't technically call it a renumbering of the first set because the first set never had numbers, but I've now assigned numbers to all of the defense tendered instructions.
Great. And then the second set is just a tendering of the instructions that you just ran through here today, and you're representing to me that those were the only changes in those instructions, correct?
The only changes in those instructions that we discussed here today and that don't pertain to other objections that I've made at previous charging conferences.
Okay. So the ones in D-292, the ones attached to D-292, those were newly tendered instructions. And the only difference between those instructions and the instructions previously tendered by you is the changes that you went through and outlined here today?
No, they're not newly tendered instructions by us. What they are proposed edits and revisions to the court's draft instructions.
Okay. And you went through each one of those here in court today?
I did.
In terms of the changes, correct?
In terms of the changes that pertain to the verdict form issue.
Okay, got it.
Not that pertain to other issues that we've discussed at other charging conferences.
Got it. So, yeah, that's what we've been talking about here today in terms of those changes. That Ms. Nelson ran through when she was going through those standard instructions. So I understand, and I've ruled on those after the people have taken a position on each of those proposed changes. So, all right, is there any objection, any other objection that anyone wants to make with respect to the instructions then? And I will have them final for you. Actually, you know what, I'll make that record tomorrow morning instead before I bring the jury in. I'll just show them to you and ask you if you have any other record. I'll ask you if you have any other objection to the order of the instructions, and I'll ask you if you have any other instructions to tender. But with the understanding that that there is no other objection, there are no other tender instructions, and these can be finalized now, all right? All right, I think that leaves us with the issue that Ms. Higgs wanted to address, and actually Ms. Teach McGuire has one too. Let's go with Ms. Higgs. You wanted to address an issue with the court related to some unavailability of potential witnesses for a possible sentencing hearing. Obviously, this is not an issue if we don't have a sentencing hearing. It's only an issue if we end up having a sentencing hearing.
Certainly, Your Honor, that's correct.
Okay.
As the court is aware, Mr. Holmes has a right to present all relevant mitigating evidence during the penalty phase of a capital trial. The court is familiar with the Lockett case that discusses that. I think the 8th and 14th Amendments require that the jury not be precluded from considering as mitigating evidence any aspect of Mr. Holmes' character and his background, as do Article 2, Sections 20 and 25 of the Colorado Constitution. And it is clear, and I won't cite a number of the cases because I know the court is familiar with this case law, but a long line of cases indicate that states may only impose the ultimate sentence of death when the court follows procedures that will assure the reliability and fairness of a sentencing hearing. This is the situation that the defense is currently in. 99% of our witnesses for sentencing are coming from out of state. We have cooperation with almost all of these witnesses in their willingness to come and testify. The dilemma falls within the issue of timing. We initially thought that August would be the appropriate time for sentencing. Now that we're ahead of schedule, we've been talking to all of these witnesses about their availability to present evidence in July or testimony in July. And we cannot ask any of these witnesses to basically set aside their entire month of July, August, and September and just wait for the moment that they would be called to testify. I don't think that that's a reasonable alternative. I understand that the court felt that this issue wasn't ripe on Friday, but this is the dilemma that the defense is in. If we come to the end of the sentencing hearing time-wise, and these witnesses are still not available, for example, the court said, well, if we start, July 27th, if they can come the first week of August, then we'd be okay. The problem is if we are not okay, we will not have the opportunity then to introduce any deposition testimony because it won't have been taken. So we are requesting that the court order video deposition testimony taken from certain witnesses, which I will lay out this Thursday and next Monday on the dates that they're available, and we're making this request pursuant to Mr. Holmes' right to due process, right to a fair trial, right to a reliable and fair sentencing hearing, right to present a defense, and right to effective assistance of counsel, both under the United States and Colorado constitutions, as well as Colorado Rule of Criminal Procedure 15. And our goal is to do what the statute says, right, to prevent injustice with regard to Mr. Holmes' right to present mitigation at sentencing in this capital case. All of these witnesses that I'm asking the court to order depositions on are available to come either and prepared to be here on either Thursday or Monday. All of them are to present testimony relating to his character and his background, who he has been throughout his life over different periods of time. We're not asking to do a deposition of any sort of expert or anything of that nature. The first witness we're asking the court to consider, and I want to make clear that the unavailability of these witnesses is based on timing, not based on willingness. The first witness was a roommate of Mr. Holmes during his undergraduate studies at the University of California at Riverside. His life's research has to do with monarch butterflies, and he is living in the mountains doing this research currently, and the time that these butterflies are available to be researched during their migration for him, it happens to fall within this narrow time period. He is available this week on Wednesday and Thursday, and after that he will not be available to August 15th, or after August 15th. So there is no time period in what we expect to be the penalty phase, should we reach a penalty phase, that this witness could come testify. And we do not have another witness in his same stature that can provide the same information to this jury.
And what's his name?
The names of all the defense witnesses haven't been released to the media, and in order to give them some protection, especially if the court doesn't allow deposition testimony and they aren't able to testify, I'm happy to give the name to the court at the bench, but I do not want to state them publicly, especially because we're coming up on a potential penalty phase. A number of people have been harassed by the media throughout this case, and I especially do not want to see that happen at this kind of sort of critical time frame. So I'm happy to give the court the name at the bench.
Okay, we'll call him witness number 1 for now. Who else do you have?
Your Honor, the second witness, I just want to number these so I get them straight later, is a family friend of the Holmes family, and spent time with the Holmes family during Mr. Holmes' younger years, up until about age 12. He has direct testimony as to the Holmes family, how Mr. Holmes was as a young boy, and in his interactions with this witness's young children. He is going to be out of the country starting July 20th and will not return until August 4th. And this is something that's already been paid for, it's already been pre-planned, and it's not something that he can adjust. And he does provide very kind of unique insight into Mr. Holmes' relationship with other children at that young age, and this dynamic with the family and what they did together. The third witness was a neighbor of the Holmes family when he was a young boy prior to moving north to Castroville. We have very few witnesses from that neighborhood at that period of time. It was some time ago, but she has a pre-planned, paid-for trip that goes from July 18th to July 31st. So she would be unavailable during that time period. I don't know if we will get to the week of August, the first week of August, simply because I don't know right now when we're going to start. The fourth witness was Mr. Holmes' teacher in 5th grade when he lived in Castroville. He is leaving the country very, very early in the morning on July 22nd, and so is not available to be here on the 21st. And he will not return until August 8th. Again, this is a pre-planned, paid, out-of-country trip. He is very willing to testify. In fact, most of these witnesses have spoken to the prosecution as well during the investigation of this case. And we don't have any other 5th grade teacher and very few teachers from that period of time to testify with regard to Mr. Holmes and his background and his character. The fourth witness is also a family friend through Mr. Robert Holmes.
I think you said 4th, but I think you mean 5th.
I do mean 5th, thank you. Through Robert Holmes, but this is sort of during this last sort of decade of time. He is leaving the country for work on July 21st. I do not believe that he will be back for the rest of the month. He is currently also unavailable because he is out of the country on work, and so I can't confirm the exact date he will be back, but he is scheduled to be here on Monday the 20th. And the last witness, number 6, that I'm requesting a video deposition of is one of Mr. Holmes' teachers when he was back down in San Diego after coming back from Northern California during 6th, 7th, and 8th grades. He has really reorganized his entire work schedule for the summer. He is actually working during the summer. He's not taking the summer off. Based on our previous estimates of when we may start, and now he can't rearrange any of those work commitments. He is available to us to be here on July 20th, and I don't believe he is available for the rest of the month. And those are the 6 witnesses that we will have here in Colorado on Thursday of this week and Monday of next week, and I can give that breakdown if the court's going to order the depositions. I don't know when we would start a penalty phase if we get there. Our other request would be to set sort of a hard date for that, because it's very difficult with all of these out-of-state witnesses to organize anything at this point in time, because if one day changes, then it kind of pushes everything back, and we have to organize plane travel from the airport, we have to organize lodging, and we've tried very hard to do this within the constraints that we've had set so far, and we're just finding it near impossible to maintain this, especially when we are having to tell these people that we have no idea when exactly they would have to come in. So that is also our second request of the court. Perhaps setting a date where we can be very, pretty sure that we would be there at that point. I would suggest the date of perhaps July 27th. I don't know what the people's position or the court's position is.
But how does that solve the problem with a lot of these people? I mean, some of these people are not available, you're saying, if we started on July 27th, so what does that solve?
Well, that will not solve the dilemma that these witnesses have, but it will solve dilemmas that we are having with other additional witnesses that we're trying to schedule. It's very difficult to schedule 40 witnesses to fly in and testify the night before we're required to start. And that's basically what the court's asking us to do. It's virtually impossible.
Well, I'm not asking you to do that. That's just the way it works. Do you still have an estimate of 2 weeks for your case, your mitigation case?
Well, I think some of that's going to depend on when it starts and the availability of the witnesses, but that's our current estimate.
Let's assume that you're able to call all your witnesses. Are you still assessing it at about 2 weeks?
That's our current assessment, yes.
All right. And I know that you've endorsed some experts. Do the people, well, I know it's hard for everyone to tell what's going to happen, but do the people anticipate that if some experts are called in mitigation, that they would have experts in rebuttal during that phase of the proceedings?
Most likely, Your Honor.
And so how long do you think that would take?
3 days at the most, I would think.
3 days at the most. So 2 weeks for them, 3 days for you. What's the people's position on the request for videotape depositions? Yes.
Rule 15 has a specific procedure, Your Honor. It envisions affidavits supporting a assertion of unavailability. There is a case apparently that says that affidavits are not essential, and that's People versus Hernandez, 899 Pacific 2nd, 297 from the Court of Appeals in 95. But that also says you don't need an affidavit where the court is thoroughly informed of the facts supporting the motion by other means. In this case, Your Honor, the purpose of Rule 15 is that acknowledgement that there are going to be certain situations where it is impossible to comply. Are when a person literally gets called up to military duty to go to somewhere like Afghanistan, and the military says, no, you can't have them. Well, there's nothing like, we can't go to the Army and say, we demand you give us this guy, because obviously the federal government's directives control under the Supremacy Clause of the U.S. Constitution, that person would be unavailable. Everything I've heard from Ms. Higgs indicates that these people would be inconvenienced by compliance with the subpoena, maybe financially inconvenienced by compliance with the subpoena, but not unavailable. They have not, I think, established unavailability as contemplated by Rule 15 for any of these witnesses. And, I haven't even been given the names of these witnesses. I wasn't given a list or anything, and Ms. Higgs talked about doing it up at the bench, but, I don't think you can just get up here and say, these people are going to be inconvenienced, let us do a deposition. It deprives the jury of actually assessing the person in person. Although there would be videotape, we all know that there's a difference. It deprives the jury of being able to ask questions, and the rule does not say that that is a dispositive fact, that jury questions would trump this. It talks about unavailability, but I think that it's got to be a reason that is more than an inconvenience, more than a financial expense, an actual impossibility or close to it to comply with the court's order to appear, i.e. the subpoena. So unless the court has any questions for me, that's what I've got to say on that point.
Thank you. Ms. Hicks, I hear what you're saying. I just don't see how you have established the unavailability of all these people. I mean, it sounds like multiple of these folks have made trips, some of them out of the country, some of them it sounds like pre-planned, prepaid. Nobody said that we would start any penalty phase, if there is a penalty phase, on July 27th or July 20th. I mean, we've all been doing our best to estimate based on what's happening, but it wasn't until recently that I scheduled closing arguments on July 13, and that changed to July 14. That was about a week ago. And it was about a week or 10 days ago, maybe 2 weeks ago at the most, that we talked about how if that's the case and if there's a penalty phase, then we would start it on July 20th if the jury had deliberated and if the jury found the defendant guilty of any first-degree murder count. I mean, some of these folks, it sounds to me like they have made these arrangements from a long time ago, knowing that there was a possibility that we would be in the middle of sentencing proceedings during this time frame. So I need to know more. I'm not saying no, I just need to know more in terms of why they are unavailable and in terms of the hardship that it would cause them to have to be here to testify in person, in terms of the circumstances they're facing that prevents them from getting here. Again, I understand inconvenience, that's one thing. It's another thing to be unavailable. And so I need more information before I can determine how to proceed. So if you want to provide that to me, I will consider your request at that point. It sounds like most of these folks, we will be able to work around their schedule anyway, but there are a couple of them that sound like, for example, the first witness is available Wednesday or Thursday and then not until August 15. That may be problematic. One of these, you don't even know when the person is back, apparently. You just know that he leaves the country, he or she leaves the country on July 21. So I need to know more in terms of when is the person available after July 21. But the rest of them, with the exception of the first witness, witness number 1, we may be able to work around. The person who's gone, witness number 4, between July 22 and August 8, if the person is leaving on July 22, you know, I'm not sure why he couldn't be here on July 21 or even July 20.
Your Honor, he's scheduled to be, and he's scheduled to be here on July 20th.
Oh, okay.
And the reason we scheduled those, Your Honor, is not because we were hoping that it would be in time if there was a penalty, but also in the alternative that if we weren't there yet, that we would have them present before the court to do videotape deposition because of the unavailability.
Okay. All right. Well, we may be able to work around most of these people's schedules. The first witness number 1, may be the most difficult one, and then I don't know enough about witness number 5 because I don't know when that witness is available again. So the rest of them, witness number 2 is available on August 5th. Witness number 3 is available the beginning of August. Witness number 4, we just talked about, he is available July 20th and perhaps July 21, maybe July 21. I don't know about witness number 5 because I don't know when he's available after July 21. And then witness number 6 is available in early August as well. So it depends on what happens, and it depends on what other information you have that I can consider. But witness number 1 may be the biggest problem. Perhaps witness number 2 as well, because that person would be available on August 5th, and depending on when we start, that may be too late. I don't know. I'm trying to do that may work depending on when we start. So the witness number 1 is probably the biggest problem. So, but I need to know more. You know, I need to know more in terms of what is witness number 1 the same person that you submitted an affidavit with respect to, who's in medical school,
No.
and couldn't make it here? No, that's just somebody else.
Correct.
Yeah, I would need to know more before I can decide whether this is something that I can, that I can grant. So,
Your Honor, we're happy to provide additional information. Could we do that? Can we have leave to do that in writing? We've been trying to contact people to get more information, but some people, like witness number 5, is out of the country right now, and so we haven't been able to determine when he would be available after July 21.
that's fine. I don't need argument, though.
No.
I understand the argument. I just need more information in terms of unavailability.
Okay.
And hardship.
And just so we're clear, Your Honor, part of my point is that if we hope that maybe we'll get there by the time they return, like for witness number 2, if we hope that maybe that will work, that we'll still be in penalty if we get there by August 5th when he returns, the dilemma is if we're not at that time, we will not have been granted the opportunity to preserve his testimony and then play it. So I think that there are 2 issues. I think the court can order the deposition testimony without necessarily ordering that we will use it. I mean, if it turns out that, for example, witness number 2 does get back in time to come in and give live testimony, then of course the court wouldn't have to order that the deposition be played for the jury. But without having preserved it, we won't have that option. And so I want to make that clear. I would also argue that Mr. Holmes' constitutional rights do trump any right of a juror to ask questions. And I did note within the Colorado Rules of Criminal Procedure, that rule with regard to juror questions has been on the books for many, many, many years. There have been amendments to Rule 15, and the legislature has not ever said that that's a reason not to allow this type of testimony. And if we're able to come up with any alternatives, we will put that in with the information that we provide to the court.
Great. The sooner you get me the information, the sooner I can make a ruling on it. So,
We are doing our best, Your Honor.
great. Okay, as soon as you can get it to me, I will review it, and then we'll go from there.
And with regard to our request to set a hard date to start penalty if we get there, is the court denying that?
Yeah, at this time, I just don't think it makes, I mean, I can set a hard date, but, I don't know that it makes a whole lot of difference. I think we just have to, it's better to stay fluid and flexible and figure out what happens. I mean, I would hate to set it on July 27, only to find out that then we are wasting a week, for example. Or we set it on July 20th, only to find out that we're not going to start on July 20th because we're not ready to start on July 20th. So it's just, we're all trying to predict, and we're doing the best we can to predict, but it's just difficult to do, so.
We are trying our best, Your Honor. The problem is with trying to remain fluid, it is encroaching upon Mr. Holmes' constitutional rights to present mitigation at a penalty phase in a capital trial. And while if all these witnesses were here in Colorado, it would be much easier to try to remain fluid because not as much would have to be organized and set up. But to ask these witnesses just to be available on a moment's notice for the next 3 weeks is becoming untenable for them, and it is likely that we will lose crucial mitigation evidence to present to this jury in support of a life verdict, and I think that has significant constitutional impacts based on the constitutional provisions I've already cited. And so that is one of the reasons that we're requesting a hard start date. And this is not unheard of in capital cases, that even if a couple days we're not presenting testimony, I don't believe it's wasting time. I think it's spending time to ensure that Mr. Holmes' constitutional rights are protected. In addition, we could set a hard start date for testimony for Phase 2 and still address, if the jury came back earlier than that with a verdict in the merits phase that required us to move on to a penalty phase, we could move on to instructing the jury and to Phase 1, I think is what the court calls it. So I think there's a little bit of leeway in there, but I understand the court's position.
What date are you asking the court to set? What solid date are you asking me to fix?
I think July 27th would be the most reasonable. I think it's most likely that we would have a jury verdict at some point next week. But we could also take a day and address Phase 1 and let the jury deliberate on that before The defense begins presenting testimony on July 27th with regard to Phase 2 evidence.
Are you asking me to say July 27th as the start of any sentencing hearing or as the start of mitigation, phase
As-
2?
As the start of Phase 2.
Do the people have a position on that, Mr. Orman?
I agree with the court's previous assertion or statement that we need to remain flexible at this point. We don't know when a jury will be completed with their jury deliberations for the issues that we've been discussing in jury instructions for today. And if they come back a lot quicker than saying, hey, by the way, you're coming back in a week and a half or a week to hear some more evidence, I think is really unfair to them. And I don't think that Ms. Higgs has demonstrated sufficient facts for the court to conclude that the procedure that we currently have, where we have flexibility, would deprive the defendant of any constitutional rights. Presumably, all these people are under subpoena. They have to come. The defendant hasn't shown, I think, unavailability. So that's all I have to say, Your Honor.
All right, Ms. Higgs, file the information related to unavailability, and we'll go from there, okay?
And Your Honor, I think I should also point out in abundance of caution, because the court doesn't want me to add any additional argument to any filings, is that under People v. Hernandez, the court cited by the prosecution, good faith efforts to obtain a witness does not require exhaustion of every possible means of securing the witness's presence. In that case, the prosecution did not have the witness under subpoena, and that was still not the issue. So that's just in response to the prosecution's last argument.
All right, thank you. All right, Ms. Tisch-McGuire, do you want to approach on your issue? And actually, Ms. Higgs, did you want to make a record as to the actual names of these folks so the record is complete?
Yes, I have.
Why don't you do that? All right, is there anything else before we adjourn for the day? Ms. Nelson?
Just wanted to confirm what time the court would like the parties here tomorrow.
Why don't you plan to be here at our usual time, 8:40? And then if we can make our record with respect to the final instructions and verdict forms at that time. I will have my staff make a copy of my list of deliberating jurors and alternate jurors for you. It's in my handwriting, but I want to make sure we're all on the same page. So, and then I'll have my staff make a copy of a corrected version of the admonishments that we're going to blow up and put in the room that the alternates are going to be kept in, okay? And then, Ms. Higgs, as soon as you are ready to file what we talked about in terms of the unavailability of some of your witnesses, file it, I will review it, and if at all possible, I'll give you a ruling on it tomorrow, okay? All right, anything else?
Your Honor, in addition to sending us a Word copy of all of the instructions, could you also send us the scanned one when it's done so that we can see which instruction numbers need to be put in if they needed for a PowerPoint slide?
We can do that as well. Anything else? No? All right, we'll adjourn. Thank you. I'll see you tomorrow. The court will be in recess.
Please rise.